B of the Constitution. He alluded to a question which the court comes across, and a question which is a request by the party. To be certain, Mr. Chairman, in this case, it is the accused persons from the amended charge sheet A2 and A3 who, through their counsel, are making this request. In that regard, the Constitution, which my colleague has repeated many times, is superior to the gallant force of the UPDF, commands all courts, including this one, to frame a question and forward it to the Constitutional Court. It does not allow this court the opportunity to determine whether there is sense in raising that question, because that is not its duty. To determine, upon response from our colleagues, that we can examine the validity of that question, or if in their view the question has been heard before, is to defeat the Constitution. Mr. Chairman, Article 3 of our Constitution says that anyone who acts in breach of the Constitution creates a very big offense, which perhaps, again referring to Mr. Walimwa here, will now bring him under his court. It is treason. So, we are urging the court, Mr. Chairman, that once we raise the questions as we have done, the honor or the duty of this court is to put the questions in proper wording and send them out, and not to determine whether the questions should be sent out, because the duty that it has been done already, there has been a request. Mr. Kalibala also referred to the Enforcement Act of Human Rights and said derogating from an underogable right, Mr. Chairman, is an offense. That should be Section 11, and that is true. As officers of court, Mr. Chairman, we do have a duty, perhaps akin that of the judge advocate, to advise the court. It is a duty the old court as officers of court. What Mr. Kalibala did not say, Mr. Chairman, is that while people executing office have got immunity of office, this particular act waives that immunity. So, the judge advocate, if it becomes aware that this court is deviating from it's not part of the court. If any of us became aware that we are deviating from a non-derogable right, we are committing an offense. And that offense is alive for between 10 to 15 years. Moreover, the defense that I was acting under instruction does not arise. Mr. Chairman, in 15 years, I will be nearing 65. So I wouldn't want my younger colleague here to keep it in his heart and after 14 years come against any of the distinguished officers there to say on the 14th of May, he took the view that they were derogating from an non-derogable right. Because the defense of saying we are executing our mandate of officers established under an act of law will not be available to you distinguished members. That is the command of the law. Our request, Mr. Chairman, seeing that my colleague referred to the attributes of a force which is patriotic, which is disciplined, and a disciplined individual or institution agrees with established rules and principles, and given that the same command the force to subject itself to civilian authority, we do request that as commanded by Article 137(5)(b), which directs the court to submit the question, that when my colleagues have raised the questions, We do not engage the chairman, and many people most politely, with questions as to whether we should refer, rather, to spend the other part of the day by getting the right language of the questions, which shall then be referred to the Constitutional Court to interpret as they are mandated to do under Section 130, Article. And my, Mr. Chairman, again, and for my colleagues from the state, led by the prosecutor, we just want to refer you, when I say my lord, it's not derogatory, the court, to Section 195 of the General Court Martial, which spells very clearly and succinctly the functions of the General Court Martial. My lord, Mr. Chairman, that section has 3 subsections, and the first subsection has got 5 paragraphs, none of which give this court power to interpret provisions of the Constitution or of any other law. We therefore request that you surrender to even replace this court, and the questions be crafted with the aid of our colleagues and ourselves and sent to the higher court for the next interpretation, so that if we are to return here following the finding of that court, we are sure that all the doubt we have about the jurisdiction, about impartiality, about extraterritorial effect, which are now the painting points, are handled, and that we can proceed peacefully and in a manner that is subject and under established law. That is my request. I thank you, Mr. Chairman, members of the panel, for listening.